Good evening and welcome to the docket. I am your host, Bob Mata, and this is presented as always by Defense Diaries, the podcast. And we're excited about this. As you may or may not know, we are pivoting from our Chad Daybell trial stream coverage to Karen Reed and the Commonwealth versus her, which is starting in earnest with opening statements on Monday. And Allison and I thought it would be a really good idea for us to kind of jump into a motion that actually was argued back in mid-March, but that both of us feel really encompasses so many issues that are going to be brought up at trial, in particular by the defense, in relation to all the players in the game. So, we're talking about the DA, Michael Morrissey. We're talking about Lally. We're talking about all the cops. Because this is going to be one of these cases where you're going to have two alternate theories that are thrown out there. Now, I've talked about this for the past month and a half about, that Delphi and the Karen Reed case are these two rare circumstances where you've had the defense, which is extremely unusual, lay out their entire theory of defense way before trial. That typically doesn't happen. It's typically we're just hearing the state's theory. That's the way it's always been. So in these two cases, and it's created these incredibly toxic communities in both of them. Like, if you go online for either of these communities, it's an absolute nightmare. And I think, honestly, that Reed's even worse than Delphi. As bad as Delphi is, the Karen Reed thing is like just this grudge match from hell where everybody's dug in, and it's so toxic that it's like it's hard to deal with it. Like, it's hard to read it. Like, I obviously never get involved with it. Like, I never get, or I try not to stay out of the toxicity of Delphi, but people keep trying to drag me in, and I just won't dip my toes in it. But man, it's something else. So Allison tells me, she's like, babe, this is the motion we were going to do, because we were originally going to kind of do a more thorough legal review, because Jay and I, my streaming partner Jay, the Shaming of Jay, have been streaming Daybell, and then today, when the hearing for Reed was up, in anticipation of us streaming that starting next week, we wanted to cover that hearing that went down today, and it was a critical hearing. The judge made her ruling on many of the outstanding motions in limine that she had kind of left hanging last Friday after the hearing. So Allie, who I haven't even introduced yet, was adamant about us covering this one. She's like, I want you to watch this hearing. As soon as it was on, I was like, oh, this is the one. So she knows. I never doubt her.
And I still think that we could touch on, because a lot of the things they speak on are sort of relevant to the pending motions in limine. So I still think we can do that. But I do want to, before we jump in to Karen Reed, I just want to say, for anybody, especially the women out there who are unaware of what transpired in our Supreme Court yesterday, and I think it's been transpiring with other states since the issue that has had the impact on Roe versus Wade. But there was a argument yesterday from the beautiful state of Idaho and from the attorney general there that Idaho hospitals, they don't the state of Idaho doesn't want them to be able to treat a woman on an emergency basis who might need to terminate pregnancy, like they've got some sort of issue with their pregnancy, and the only way to keep them from having a very serious medical issue, including losing their reproductive system, they need to be given a medical abortion. But under Idaho law, it has to be life-saving measures only. So they were saying, don't I mean, yeah, if she comes in and she's not dying, but she's gonna lose an organ or a leg, the doctors have to send her home or they could be charged with under the Idaho statute. Um, and although the women justices, at least some of them started to shout out and ask a lot of questions right off and seem like they were gonna, be very firm. The conservative justices kind of think that the government shouldn't be telling hospitals that they have to give women medical abortions unless anything short of death. If they're not gonna die, oh well, then you don't
Yet
have to
they
do it.
think that the government should be telling women what they can and can't do without their bodies.
They don't even see that. They don't even see that. That's
Yeah,
not even
it's
so there
it's
you
just
have it. We should all be paying attention to what hospitals our pregnant friends go to make sure if there's some sort of emergency that, they'll be given whatever medical care they need, and, um, yeah, so it's pretty disgusting. But sorry to steal the platform, but,
uh,
um,
it's
so
your platform too, babe. So,
so
and
Karen Reed.
it's a disturbing issue. So
Yeah.
yeah, Karen Reed. Um, you
And
know,
I have to say the reason now there's 2 things, like, obviously, this is a woman who is she's not being held in custody, so you don't have all that side of the horror that you have in the Richard Allen case. But not only do you have police not investigating and just kinda going with whatever they want, you actually have it where the other people are the police, and, I was shocked that the judge in this case, had no issue with the prosecutors remaining on the case after this hearing, and that's kinda why we're gonna start here.
yeah, and it really does. It really beautifully like just captures like so many of the issues in this case. And and if y'all aren't really familiar with the Reed case, I highly recommend that you can jump back and check out Jay and Stephen Dan from Publicly Buzzed and I did kind of just like a basic primer, just trying to give you guys a heads up on who the players in the game are, in terms of attorneys, the defendant, obviously John O'Keefe, the victim, as well as some of the primary witnesses that you'll be hearing from in the trial, and the theories, both theories that are out there. So if you haven't kind of dug in, I think you're going to want to. I personally believe this is going to be one of the best trials. And when I say best, I'm talking about it's going to be well litigated. I think that you'll find that the defense team is top notch. I mean,
She's got
these
the OJ
guys.
defense team for sure.
She does. I mean, she shipped in Alan Jackson from California. He's a California lawyer. I guess he infamously, or however you want to look at it, defended Kevin Spacey, and got him a not guilty in that aggravated sexual assault case
Mm.
that ruined his career either way. He may have won that case, but he did not win his career back. But he is an exceptional attorney, as is Yannetti, who is a Massachusetts guy. Both of them are great. And Melanie Little is the third attorney, who is young but ferocious. I've seen her argue a few times. You can kind of hear the quivering in her voice of that is not untypical or atypical for a young lawyer, especially in a case that seems to have the eyes of the world upon it. So I ain't sweating her because she's getting her words out and she's making powerful arguments. So what we're gonna do, we're not
Why
gonna
don't
be
we give him a little background, right? So,
yeah, give
um,
them the
I mean,
you do it.
I'll try it, but I don't really know all that much. So, John O'Keefe, is that right?
Wow, you don't even know the victim's name. You're already
He's the
starting off on
victim,
the right.
and he and his girlfriend, Karen Reed, were out with a group of friends. It was really like another group of friends that they had a common friend with, and they were all having drinks for this one guy somebody Albert's birthday, one of the Albert's crew, at the end of which they were having like an after party. So John and Karen decided to go. When they get there, Karen's like, "There's a blizzard. This is no, I'm out. These aren't even really our friends." He wanted to stay anyway. Sounds like they got into a bit of an argument there. And then the big question is, the whole dispute is, where did he go when he got out of that car? Either he went into the house and there was some sort of fight at some point, and then he was thrown outside into the snow and left to die, or as Massachusetts will have it, she decided to back up 21 feet. No, drive forward 21 feet. Yeah,
Yeah.
drive forward 21 feet, look at him in the rearview mirror, floor it, and kill him with the car. And then she went home. Hours later, starts looking for him, calling, getting angry. He's not calling back. And where the hell is he? And what's going on? When she calls over to her friends at the Alberts to find out if he's there, she's given at least this is what I heard. Now, I'm not even sure on this, but one of it was an ex-Fed or something that Bob and I saw last night said when she got that phone call, the answer was, hold on. And then not like, no, he's not here, whatever the case may be. And then he's found, there's a more to the story, but ultimately he's found dead in the snow. Now, he does have a glass in his glass by him, a cocktail glass. Seems like the cocktail glass he took from the bar. There is video that he took a cocktail glass from the bar. When Bob and I talk about this, I'm like, well, what's the explanation for why he still has that cocktail glass? You can't tell me he went inside, spent any amount of time in there when he's almost dead, gets tossed out with his cocktail glass in his hand. But you've got, experts from one side saying it's impossible for his injuries to have come from a car. You've got experts on the other side saying this is not a fight. This was somebody
No dog bite.
yeah,
He's,
and
you got
I don't know about the dog bite or not a dog bite. I honestly don't, know enough about it, but you also have, um, you've got, um there's a lot. So I don't wanna mean to be seeming like I'm giving it one side, a very
You already
one-sided.
did when you gave some kinda like some dude that we saw last night on a YouTube talking about a phone call telling him that like, we
Right,
don't
I don't know if
like,
that
I'm not
happened.
substantiating that,
Right, I'm
like,
not substantiating it. I almost take it
you
back.
kinda
So
did though by,
I
like,
did,
mentioning it.
because I was like, "Wait,
So,
what?" So, yeah, forget I said that part. So, anyway, that's the big dispute, and there were pieces of her tail light in the in the snow that they eventually found. The question is, did they find it, like, sitting on top of the snow like it magically was put there, or was it mixed into the snow? You've got this, video of whether or not she was pulling out of the house earlier at 5 in the morning, if whether or not she hit a car. I didn't think it looked like she hit it. Bob thought he looked like he hit it. I'm trying to zoom in on the snow and be like, "All right, where's the little pieces of" she broke her tail light right there, right then and there. Let's see it sitting on top of the snow. I don't know how soft the snow was or wasn't,
well, what's
you know.
significant about it is a nor'easter had come in that night, so this is all fresh snow. Like, so the concept that had the tail light been broken earlier in the evening, i.e., when she allegedly strikes John O'Keefe, how is it that the taillights that they find are somehow on top of freshly fallen snow,
But
as
do we know
opposed
for
to
sure it was
being,
on top?
yeah,
No, well, that's absurd.
yeah. Well, it's, I mean, like,
And
so
another thing that happened that was highly suspicious, was that so when you take the car, like the garage part of a police station, sort of like where they pull their cars in, if they've got somebody in the back, it's called the Sally Port. At least the ones I'm used to are called a Sally Port. I don't know if they're called other things there, but Bob and I were watching another hearing on this case, and it was like, where are the missing hours in the Sally Port? So, an important thing I forgot to mention was the relationship. So, all the guys in the house, they were also Boston cops. So the victims are Boston cops. All the people in the house are Boston cops. One of the family of this Albert family has a very close association with the chief or somebody important in the Boston police
I don't think they're
department.
all Boston cops. I think there might be a Canton cop.
Yeah, something like that. All
Yeah.
right, so area cops, whatever the case may be. And the car, so Sallyport's the cameras are motion censored. So when the car pulls up in front of it, the cameras click on. Well, this one's missing, I forget how many minutes, but a substantial amount of minutes where the defense is saying that inside that Sallyport was this one chief or sergeant, whoever he is. And I'm sorry, because I honestly don't know all this, but was in there with some other officers associated with like these guys, and they're alleging that at that point they took some pieces from the the what is it?
To what?
The taillight,
Yeah.
and took it back and like put it gently right on top. I mean, we don't know where they found it, so maybe she did hit him there, and maybe they did also decide to put the pieces there because they didn't find it, or maybe her taillight was hit when she was pulling out, but this is what we have. So what we're about to play is a pretrial
You forgot,
motion.
I think, which would to me is
Oh,
the
yeah, go ahead,
biggest.
tell them that part.
Yeah, the biggest piece of evidence in controversy is this uh, Google search that took place. Now, what's at controversy is when it took place. The defense and their expert is alleging that they
There were
found it
3.
in the Cellubrite acts in the Cellubrite extraction report that this search for HOS hose supposed to be how long to die in the cold took place at 2:27 a.m.,
And
which
also at
obviously
6. They said there were 3 searches, 1 at 2 something and then 2 in the 6 o'clock hour.
I was getting there.
Sorry.
But that's what's a controversy. So the state is saying no, that is not the case. The first search takes place at the behest of Karen Reed when she tells Jen McCabe, "Hey, text how long to die in the cold."
Search.
When they find yeah, or text or search how long to die in the cold. So there's a huge discrepancy in terms of when that takes place. Obviously, the significance being that if it takes place at 2:27 a.m., it's evident that clearly John O'Keefe is there and he's been there and they're aware of it. And how do you explain that no one would have called 911 if they're texting about how long it's going to take somebody to die in the cold, which goes along with the entire theory of defense, which is something happened in that house. Probably John O'Keefe got a beat down. They don't think that they killed him. They probably think that they knocked him out. Probably said, you know what, drag his ass out to the front yard. He'll get up, he'll wander off. We're good. He just continues to lay there. He's not getting up. He's not wandering off. Hence, this text takes place. And then the worst possible ending occurs and
The
John
Google
O'Keefe
search.
passes away. So that is going to be a massive battle in court. And to me, it's really the most critical piece of evidence. I mean,
And
the
it's a
rest of it.
227 Google search. Bob called it a text. It's a
Yeah,
search in Google.
I think I initially called it a Google search, but I after that
Oh,
called
the other thing we need to mention is that so she drives over, I think, so her friend that's there at the house where the party is this McCabe woman. That's the one she calls like, "Where's John? He's not answering. He's not, So they get in a car together, and another one of McCabe's friends follows them. She leaves her car. Now, I don't know if this is true or not, but it sounds like what the defense's kind of version is that when she leaves her car there, she notices as she's getting back in or they're pulling out and their headlights hit her car that her tail light's broken. And she's like, says something about, oh shit, my tail light's broken. They're like, how'd that
cracked.
happen?
She
Or
says
cracked.
cracked,
Right.
right?
She's like, I don't know how that happened.
Yeah, you're
Um,
kind of getting half things right. So when she leaves the townhouse to go search for John, and we're talking about Karen Reed, she's backing out because they had both taken the Lexus to go to the Waterfall Bar that evening. And then when Karen drops him off, thinking that he's going into the party, she decided she didn't want to go in. She went home, went to sleep, or presumably went to sleep until she's texting and like Allison would be doing with me if I just wasn't answering her texts, like, where are you? Where are you? She'd be like, where are you? Like, what the fuck? You know, where, like, I'm gonna kill you. Like, I'm gonna come
Oh,
get.
really?
Yeah, so it's like any caring wife would do, or girlfriend, right? I mean, if you're not hitting them back up. So at any rate, when she's pulling back out of the townhouse because she had parked in the garage, O'Keefe's vehicle was parked there, which is another SUV, and you can see because they have there's a video. I don't know if it's a ring camera or if it's just a fixed security cam, but they have footage of her backing up, and it appears that she could have hit that vehicle. She comes very, very close to it. I happen to think when I watch it that she gently nudged it, which would certainly be enough when you have that much weight hitting a sedentary object. It's gonna theoretically would crack the tail light. So I don't necessarily know that it would shatter it. I mean, you can't really see any pieces of the tail light laying in the snow when she pulls away. So, but that's another fact that's going to be in obviously very, very adamantly argued by both sides. So it's a fascinating case, and there's just two diametrically opposite theories out there, and we're going to get to hear them both. I mean, a lot of times when you have cases, you just don't have two fully fleshed out theories, both of which are plausible to people. I mean, no matter if you've already dug in on this case and you've got a position, whether it be the state side of it or the defense side of it, you believe that that theory that they're putting forth is not only plausible, but actually what happened. And that's why we have trials. We have trials to vet all the evidence so that we can see what's what. When I hear the experts on that Cellubrite stuff, to
Yeah, and
me,
by
that
the
is.
way, sorry, I'm just because I've been telling Bob this I don't understand, this isn't up for debate. It's like every so it is what it is, what it is. I've never seen experts not be able to agree on the time things happen on a cell phone. When they use these systems, it's gonna, like correlate the time to the world time, tell you how many hours to subtract or add to get to that time. So I'm going to be super interested in how two different experts can come up with two different times on something that is supposed to be black and white. And what I find most interesting is that the one thing you can tell from this case is that you've got like very serious experts, like not just like fluky experts who are on completely like different sides of this. And you've got this Cellbrite is what we use in every courtroom almost, in the United States. So now all of a sudden, everything that people are getting convicted on every day across this country is seemingly bullshit. So,
Yeah, it's interesting. It's interesting. All right. So, hey, we
yeah.
got so my Freudian slip when I called the third lawyer, Melanie Little. She is actually an attorney. She's got her own awesome YouTube channel, and she's hanging out with us, and she's steeped in Karen Reed knowledge. So,
Oh,
welcome. Thanks
I'm
for hanging
sorry
with us,
because I really
Melanie.
don't know what I'm talking about. So hopefully you can chime in and correct
Yeah,
me when I
I'm
say
sure Melanie
something
was
wrong.
sitting there, oh, she
Ah, she's got
screwed that
that.
fact up. Screwed that fact up.
So it's
Uh
just facts-ish tonight, everybody. It's just facts-ish.
just fact-ish. But what we won't screw up is the law. So tonight we're not reading. Tonight I'm gonna throw up. I want to watch the hearing.
It's not too long.
Allie, yeah, it's a great, just a great hearing. I really I enjoy it, but I'm a law nerd, so hopefully y'all enjoy it. And Allie, feel free to tell me when you want me to pause it, or if you have the ability to
I
pause it
don't have the little
yourself.
hand.
Yeah, I think
Let's
Scarlett
see.
took Tiny Hand from me, which I don't appreciate. Um, all right, so without further ado, let's start. Let's start with this bad boy here.
You're gonna no, get it to the time when the other lawyer starts. We don't need to hear the first.
You don't want to hear
I
the
I just think it's too long to do that.
let's see. Okay,
About halfway
so
in.
after Alan,
Yeah. Although that's also like a really interesting argument. I just
do you not want to hear that argument, or you
no,
want to
I
go
think
right
that
to
we wanna
you want to
go
go right
right
to Yannetti? All
yeah.
right. Okay. I didn't realize you skipped this whole thing. I would have forced you to. Okay, so here it is.
I didn't know I could keep your attention that long, so that's why.
All right, so let's try to fire it up from here.
We believe our witnesses.
Perfect.
They are telling the truth. Karen Reed is guilty. Any suggestion to the contrary is a desperate attempt to reassign guilt. Can you imagine a district attorney with a sworn duty to do justice and respect the presumption of innocence issuing such a statement in a pending case? Before August 25th of 2023, I could not. Yet that was the message of Norfolk County District Attorney Michael Morrissey to potential jurors in this case on that date. I've been practicing criminal law as both a prosecutor and a defense attorney for over 30 years now. Never have I seen such unethical conduct from a prosecutor. I know of at least one law professor who used Mr. Morrissey's statement in his class to teach his law students how a prosecutor should not act. Another member of the bar has already reported Mr. Morrissey's conduct to the BBO. And now we are here with a motion to disqualify Mr. Morrissey from further prosecuting this case because he has a personal interest in the outcome. Your Honor, this court should grant our motion to disqualify. And at the outset, I note that we've also moved for sanctions, dismissal of these indictments as a result of his misconduct. But we have so many additional grounds for dismissal as a result of the material provided to both sides by the federal authorities that we will be filing a further motion to dismiss for extraordinary governmental misconduct. My co-counsel has spoken to that previously. To the extent that the court entertains our motion for sanctions, specifically dismissal, as a result of his egregious.
Can I just interrupt there and ask you, are these going to be the same motion essentially?
No. There's information and evidence that's been provided by the federal authorities which deals with the egregious conduct of both the district attorney and his investigators and the police. That will be the subject of a separate motion, Your Honor.
So I thought that was going to be your supplemental memo to this motion. It sounds like it's the same issue, Mr.
No,
Benetti.
it's not. And what I'm saying to the court is I have limited time.
When I interrupt you, I stop the time.
Well, I appreciate that. But even with that, Your Honor, the focus of my argument is going to be on the disqualification as opposed to the dismissal. I've submitted papers on the dismissal. I will rest on those papers with regard to that issue. That's my only point.
All right. So when you file the other motion, I need you to include in your memo how that's different specifically from this.
Understood.
Not just the remedy, but how the basis of
Understood.
it is different.
Understood.
All right. So I'm going to start you again from scratch. Go right ahead.
I appreciate it. Well, Your Honor, this case admittedly has been an unusual one for a district attorney to deal with. The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial. What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court, and as a result, their narrative and theory of the case becomes widely reported, while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so hard and for so long to get access to over 2 long years. So along the way, we spoke out about our findings of exculpatory evidence, mostly within this courtroom, but occasionally outside. The DA was not used to that and apparently didn't like it because they initially sought the extraordinary remedy from this court of trying to gag the defense from exercising our First Amendment rights to discuss a client who at all times is presumed to be innocent. And as you know, they filed that motion on June 9th of 2023. and it didn't work. The court denied the motion, specifically ruling that any statements attributed to counsel could generally be characterized as responses to the accusations against Ms. Reed and are therefore permitted under the rules. When you made that ruling, though, Your Honor, you admonished both sides that commenting on the credibility of witnesses would have a prejudicial effect on the proceeding. And at that point, we largely stopped making extrajudicial statements.
Largely.
By contrast, Norfolk County District Attorney Michael Morrissey, only 25 days after that court's ruling, instead decided to blatantly ignore this court's admonishment. DA Morrissey went off the rails, gave an unprecedented video statement to the media where he specifically vouched for the credibility of Commonwealth witnesses in violation of the rules of professional responsibility, in violation of this court's order. A member of the public issued a public records request, and we got this to show all of the media outlets that DA Morrissey made sure received his statement. Before any trial has occurred, he called the defense theory in this case, quote, a false narrative. Before any trial has occurred, he announced his opinion that nobody within the home at 34 Fairview participated in any murder or any cover-up. Before any trial, he vouched for the credibility of Commonwealth witnesses Jennifer McCabe, Matthew McCabe, and Brian Albert. He announced that those witnesses were forthcoming. In other words, truthful. Before any trial has occurred, DA Morrissey announced that the defense theory is, quote, a desperate attempt to reassign guilt, end quote. Given those broad statements of Mr. Morrissey's opinion that Karen Reed is guilty, can you believe that the DA in their opposition to this motion had the audacity to claim that DA Morrissey's words were narrowly tailored to the harassment of witnesses? It goes without saying, but your words are not narrowly tailored if you're a prosecutor vouching for the credibility of witnesses, particularly after a judge told you not to do that. Your words are not narrowly tailored if you're announcing to the public that you've already assigned guilt to a criminal defendant before trial. A desperate attempt to reassign guilt. DA Morrissey announced to every potential juror in Norfolk County, not that someone charged with a crime is innocent until proven guilty.
Which they're
The words
supposed to
innocent
say, by the
until
way.
proven guilty never came out of his mouth. Instead, he announced his office had already assigned guilt to Karen Reed. So in his view, when she fought back by reasserting her right to be presumed innocent, he deemed that a desperate attempt to reassign guilt. Never in over 30 years of practice have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. Never have I witnessed an elected DA trample on the constitutional rights of a criminal defendant who enjoys the presumption of innocence. And I do have some perspective in this area. I had the privilege of spending the first 10 years of my career as an assistant district attorney in Middlesex County. I had the privilege of working with and for some of the finest DAs this Commonwealth has ever seen, from Scott Harshbarger to my mentor, Tom Riley, to Martha Coakley, Jerry Leone, Marion Ryan. In addition, I worked with some of the finest Massachusetts state troopers acting as homicide investigators, men and women I respect for their integrity and prowess as ethical investigators. In a million years, I could not imagine any of my former colleagues and bosses making such a statement. They were professionals with ethics and a humble respect for the awesome power they possessed as public prosecutors. So for those reasons, in some ways, it pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand. So the question then becomes, why did he do this? Why did he take such a personal interest in this case, such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had with the U.S. Attorney's Office which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was a lie. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023. We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury."
Wow.
Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back and forth confirmed that DA Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe? And he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had a personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see you're reading, so you have some idea on how much longer you have. How much longer do you have with that?
Probably about 3 minutes, Judge.
Okay, yeah, go ahead.
Thank you.
Oh, gee, thanks, Judge.
Indeed, Your Honor, Justice Jackson practically spoke to DA Morrissey from the grave. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have citizens' friends interviewed. Prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. Well, while the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, DA Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated. And it doesn't matter if his belief or knowledge was right or wrong. It's only important that he believes it. And this means he has a personal interest in getting Karen Reed convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, That would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. And it's important to note, Your Honor, both sides have been made aware multiple times that as we have this hearing today, that federal investigation is still open. They've called most of the Commonwealth's witnesses to testify, but they're not done. DA Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Reed is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, DA Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation. And I'm just about ready to end. The DA also, as my colleague has indicated, I'm sorry, the FBI has confirmed that Jennifer McCabe Googled, how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time. There was a lot of suspicious activity in the early morning hours of January involving the witnesses that Morrissey improperly announced to the public were telling the truth. We're getting to the bottom of it, and the truth will come out. But as we continue to defend her, Your Honor, like any criminal defendant, my client deserves a neutral, impartial prosecutor interested solely in justice with no vested outcome in this case. And it's crystal clear we do not have that in Michael Morrissey. That is why he should be disqualified from this case. And that is why I urge you to do just that in the interest of impartial justice.
All right.
Now,
Thank
pause
you
it a
very much.
second,
Who's
babe.
arguing this? You, Mr. Lally?
So just so you guys all know, we are still going to go over today. We thought this laid a little bit of, it's relevant to a lot of what was discussed today. And, so we're still going to go over everything that happened today. You're not going
God
to keep
damn.
going?
God damn. Yeah, I am. I love a great defense attorney. All right. So what we're going to do, what makes the most sense is let's watch the press conference in question right now.
It's 5 minutes, so it's not too bad.
It's well worth it. It's well
Yeah.
worth it. It's good to know what Yannetti was talking about. There's no better way to do that than to watch the thing itself. So let's check that out.
Statement of its kind.
Well, wait, pause it real quick. Sorry.
Like this, you could
And then you actually rewind it because this beginning part was good too. So what prompted this was an allegation that the witnesses were being harassed because there were people who were kind of coordinating, like, we know you did this, tell the truth, come out, very publicly, sort of in their face about it. So that's what he's going to be talking about, like witnesses being harassed and accused of crimes. So
Ready?
Yep.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one.
The district
Some
attorney.
have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. but phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe
Did we lose sound?
and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong.
Just Karen Reed.
And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence.
The irony.
The
Of
I
internet
know.
has no punishment for perjury.
Oh,
And the
God.
internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
There it was.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial.
Wow.
It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court.
Oh, Lord.
But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
Do the witnesses need a fair trial? I'm a little bit confused. Do the witnesses need a fair trial? Like, it doesn't even dawn on him while he's saying the words. First of all, just so everyone knows, that the reason the defense attorney was saying things like that he, basically put down the entire defense and vouched for their witnesses because they are not allowed to do that. Like if he had done that at trial, it would be a mistrial. So the things that he's saying there, like that is a huge no-no. They are not allowed to comment on the defense's case. They are not allowed to tell the public or the jury that the defense's case is bullshit. It's just not the way that it works. So I guess now we're going to go back and hear what the state has to say for themselves.
Yeah, I mean that was something, right? That thing was
It flies against the constitutional values of a fair trial.
everything that Yannetti said was put into context. That's why I didn't play it first. I wanted to have you all hear David Yannetti's eloquent words so that you could put that thing into context, which now we will let's check out what the state has to say for themselves.
And the rest of this is very quick, and we're going to get to the analysis from today. So
yeah, it'll be this will be good. You guys are gonna like this. It's it's interesting. Remember, we're not biased. Remember that. Okay. All right. Okay. All right.
That impinges on her right to a fair trial, or it impinges shows some sort of deleterious motive on behalf of the district attorney in the handling of this case. The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers. That is largely what this was in response to, and is in complete conformity with Massachusetts Rules of Professional Conduct 3.6b6 that permits an attorney to make a warning of danger concerning the behavior of a person involved.
did he warn anybody?
Is that a warning of danger? That's what that was?
To an individual or to the public interest. It's also in conformity with
Thanks, Lally.
Rules of Professional Conduct 3.6c.
This one could be
Which
something.
allows for such statements to rebut the prejudicial effects of the defendant's and her counsel's misconduct. Now, again, I know the court has read through the Commonwealth's opposition, but just to highlight a few of those particular incidents. So yes, the July 31st, I believe, was the ruling in regard to the, for lack of a better term, a gag order. And I think it's been somewhat inappropriately or just patently falsely represented to this court in public what that ruling said. It indicated that the statements of counsel arguably crossed the line of permissibility under Rule 3.6, and that meaning defense counsel. That the inflammatory statements about the Commonwealth and witnesses, particularly by Attorney Jackson, appear to have fueled much of the publicity in this case. And that's a quote from the court's ruling. And that the defense counsel did not have carte blanche to speak with the media, and going forward, defense counsel should ensure that their statements are limited in conformity with the rules. And it denied the Commonwealth's request for that gag order at this time, denying it without prejudice. And then Mr. Yannetti wants to get up here and say that they largely stopped making extrajudicial statements after.
Yeah, it sounds like that might have not been
largely
very fair.
stopping would then include August 22nd, the day before the district attorney's statement, a ABC News broadcast in which Mr. Yannetti and Mr. Jackson were featured for a 9-minute, 37-second segment, in which Attorney Jackson indicated that pieces of taillight were planted after the fact, that the victim walked into the house. I think he was confronted, was likely brought down to the basement. I think the confrontation got physical, and he was beaten to a point of unconsciousness, that he had defensive wounds, bruises on the back of his hands, largely of which is all not only not true, but directly contradictory to the vast amount of evidence that has been turned over in this case. Mr. Jackson then went on to continue that this was a cover-up, and indicating that John was murdered inside that house, his body was placed outside. This also continued into September, September 17th, the defendant traveling with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer to the victim's home, to Mr. O'Keefe's home, in direct violation of the
nice.
conditions of release, where she has to stay away from, as well as other places of interest and sort of tour around the town of Canton. When balancing the amount of public and prejudicial statements made by the defendant and her counsel, the Commonwealth would suggest that then characterizing the district attorney's statement from over 6 months ago, threatening her right to a fair trial, is simply a position that's just untenable. Now, in context, as far as those particular statements, those particular actions go,
That's the victim's mom.
as the court is well aware, there is a significant history between this defendant, Mr. Yannetti, Mr. Jackson, and the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this case. And with reference to that, there is a significant, despite public indications to the contrary, that indications from Mr. Kearney's phone, which was seized, is that there is a precipitous amount of phone communications, indications of communications between Mr. Kearney and Ms. Reed on a signal messaging app, an encrypted app, as well as, I believe, about 189 phone calls over a span of a few months. And that's just what's indicated or contained in the phone. There is also, going back to the spring of 23, direct communications between Mr. Kearney and Mr. Yannetti and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date in May of 2023. And this is a person who counsel in the memo seems to want to distance themselves from, based, I'm presuming, on subsequent indictments. But the truth is in the phone. The phone doesn't lie as far as those communications are concerned, as far as those communications between counsel and between the defendant in this particular case. So to say that this is a different case, again, I would suggest is a large minimization of what actually has transpired here. Lastly, what I'll say in reference to the federal grand jury, what is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti. So to claim that he was in the dark or didn't know about this federal investigation, every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth. Nothing was asked for from the district attorney's office, the state police. So again, what I was intimating before in reference to the motion to dismiss, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. It's all sort of been provided and colored by Mr. Yannetti. And this goes back to November of 2022. So to then claim that you were sandbagged or didn't know about an investigation that you initiated over a year before until late in December of 2023 is, I think, disingenuous is
An understatement.
Disingenuous would be about the nicest term that I can come up with for that. Thank you.
All right. Mr. Yannetti, a short rebuttal, I guess, or a short comment.
I would just add, Your Honor, that the focus of Mr. Lally's argument was on everything except for Mr. Morrissey's conduct. Just like it doesn't matter if Mr. Morrissey and his office are actually targets of an investigation, it's only what he knew and believed. Similarly, with regard to his conduct in keeping secret the existence of a federal investigation, it doesn't matter whether we knew about it or not. It's the fact that Morrissey knew, kept it secret for 7 months, and didn't reveal it to the defense until the media got access to those letters.
Or the
And with
court.
that, I would rest.
Okay. Thank you. So I do have a question. Did you file the Rule 17 motions already, or do you expect to file them later today?
We will be filing them by the close of business today.
Okay, and they're pretty much outlined in your previous motion, what you needed to file, or are there additional ones in your
I
motion?
believe
with the
they're
continue-
outlined. Yeah, they're outlined,
I think
Judge.
you're good.
Okay, I asked because Mr. Roach told me that on the March 20th date, the council wants it to be via Zoom. I'd prefer it not be, Because with Rule 17,
right,
as you
let's go. She's
know,
done with this.
the record holders come
Done?
into
All right.
court and object. So I don't.
Yeah. So that was what do you think of that? Was that a knock on the window? You like apples? What? You like apples? How you like them apples type shit?
It
Not
sure
really.
was.
Not
But
really. I'm talking about Lally's thing, not Unetti's.
oh no, yeah.
Yeah, I don't know.
But the judge doesn't really seem to mind. Obviously, she denied the motion, although I can't imagine there's ever been a situation where the prosecuting authority is being investigated by the FBI for their handling of the case and they stay on and no special prosecutor is assigned. It's shocking. It's appealable. It's a huge issue. And, I just don't even get it, honestly. But I think it's gonna, if they actually had gotten a different prosecutor, there's a lot of this stuff that they wouldn't be able to bring out at trial. So it's gonna play into the defense pretty damn well because as you can see from today and what we're about to cover more of what happened today, that's a lot of what the evidence they're kind of fighting about, what gets in, what doesn't get in. Um, so turning to today, and I don't know, babe, if you've got like a certain motion that you want to start with. I took a lot of notes.
Um,
Uh,
you don't want to do the video, do you? And by the
no,
way, obviously the end result of that incredibly
denied.
powerful motion by the defense, it was denied as we're on the precipice of opening statements on Monday. Clearly, Lally and the crew and Morrissey were not removed. And remember, everything with respect to the judge has to be looked through the lens of the defense had made a move to have her recuse herself prior to this. So the defense had said that she was biased. And anytime the defense attacks the judge and says, we don't think that you can be
That's not good.
unbiased, an objective, and all the things that you're required to be as a judge, it's never going to be good for the defense moving forward through the
But I
case.
do think a lot of her rulings, she was very fair. I thought that she made, I can see that she's like giving a lot of pushback in her mind on like the big things, but I think all of her rulings were pretty fair.
Are you talking about what we're about to go through?
Yeah, and
So,
I can start with the first one, which is dealing with the manner of death. So the the death certificate, and you know, the medical examiner usually will say whether it's murder, suicide. There's actually a list. I don't know all of them right now, but um, and is it undecided or into, you know, I don't know what's the technical word for when they can't make a, can't say one way or the other. Like, what does it say on the death certificate?
undetermined.
Undetermined.
Yeah.
Sorry. So, and the law does say, like, if it were to say murder on it, it's supposed to come off because that's just telling the jurors the answer's murder. So the state wanted the undetermined to come off. So what the judge said is fine, it can come off of the actual death certificate. So when the jurors get the death certificate, if they want to take it into the jury room, it's not going to say the manner of death one way or the other. But of course, the defense can cross examine the actual medical examiner and it can come out in cross examination. So that is the fairest way to handle it. It's what should have happened. I've got no issue with it. And I think it was very, very, a very fair resolution. Um, the next thing that they wanted to do and that they talked about was um, the federal investigation, whether or not they're allowed to mention at all that there's a federal investigation. Now, personally, I don't know that that I agree with it. So that was granted. They're not allowed to tell the jury that um, that there is a federal investigation. And just to make it clear, the federal investigation is into this investigation. How the police didn't, go into the house, all of the things that happen in this investigation. They are investigating whether there was official corruption involved in the investigation of this offense. Um, so then the other thing they wanted is the Commonwealth wanted they wanted to exclude any third party, some other guy did it defense type things. And the defense, I thought, put forth a very strong argument that they've got enough to get over the hurdle where there's at least something there. And the judge is like, not yet. So they are not allowed to mention it in their opening because she doesn't know whether they are going to put in enough evidence to be able to move forward and actually um, you know, assert a third party actually was responsible. So she's leaving it where they're not allowed to talk about it um, in the opening. Now, the next thing, or one of the next things that they talked about, is they're going to do a viewing, which means like the whole jury is going to leave and they're going to go, I'm assuming, look at the driveway in the house where the body was found, where the party was. And again, I thought it was a very fair ruling because it's up to the judge, as the defense acknowledged, about whether or not the defendant has a right to be present for the viewing. And the judge said for security reasons and also because she thinks it will be a distraction, she doesn't want Karen Reed there. And I think that was fair. What do you think, babe?
I do. I think it was fair. And just so, because we kind of switched gears a little bit, what Allison's currently going through right now,
Sorry.
on Friday, there was a litany of what they call motions in limine that were filed by both the Commonwealth and the defense. And it's typical to see that on the eve of trial because most of these motions are dealing with, they can be housekeeping matters. They can be substantive issues such as evidence that either side is trying to keep out or trying to get in. In this case, as Allison was aptly noting, one of the big things that came up was, the third party culprit defense, how much she was going to allow. Was she going to allow it? When they first brought the issue up, the judge had said, "Oh, well, did you put it in writing?" Obviously that was, when when the judge says that in a case like this, where the defense's theory has been out there for over a year and everybody knows what it is, it was talking about disingenuous. Everybody knows, so it's like when she says things like that, it makes me bristle up a little bit. Because you always hope that she's going to be able to do her job properly, because at the end of the day, this is about trying to get justice for John O'Keefe. And what that means is making sure that the right person or persons are convicted of the crime, and if she's leaning heavy one way and not doing her job the way that she should, and somebody as a result of her leanings gets convicted, and that happens to be a person who was not actually the culprit, we haven't achieved justice, have we? So, the hope is that she's going to be able to do her job properly, because look, she's not the trier of fact. There's a jury that's a trier of fact. This isn't a bench trial. The defense isn't insane. They would never have gone on a bench trial in a case like this. And in a case like this, had it been a different judge, there might have been a thought about bringing this as a bench trial. It's got a lot of nuances. It's got a lot going on. It's got
It also has a
uncomfortable.
lot of I don't think any lawyer in good faith could actually go, unless they had some judge who they like has this reputation for being like rogue and being like, I don't give a shit, I'm going to say what it is when it is, because otherwise they are literally blaming the district attorney, the Boston, like the local police, all the people who are in that courtroom all the time, you know.
100%.
So it's very difficult for a judge to be like, yeah,
And if you watch our content you've heard our stories about, our experiences in courtrooms as criminal defense attorneys when we have challenged the integrity of the police and how judges have responded to that. They don't take kindly to it. Many times they have taken the prosecutor track to the bench. And many times they have had these cops testify in their courtrooms over years sometimes. And when you're coming in besmirching the integrity and the character of some kind of law enforcement officer, they come at you hard, and it's like, it's one of the tough things about being a defense attorney is, when you cast shade on either the prosecution or law enforcement, it's seen as a personal attack as opposed to us just doing our jobs, because this concept that every cop is honest, that every prosecutor is honest is obviously bullshit. Obviously attorneys, we all take the same oath, no matter which side of the bar you're on, whether you're a prosecutor or a defense attorney, we took the same oath to uphold the Constitution. But, it's just not well received typically. And these guys know that. Both of these guys, and I'm talking about Jackson and Yannetti, have prosecutor backgrounds. They're those, who I consider to be the lucky ones because they've done both. They have that advantage of knowing some of the inside pool or inside poker, the tricks of the trade that come along with only working in a prosecutor's office that prosecutors typically will not make us privy to as defense attorneys. So they've got that advantage of having tried cases from both sides. And, it's like, it's tough. But so what I'm going to do, Al, I'm going to throw up
I was actually going to ask you, is it going to be
I'm just going to throw up the list. I'm not going to throw up the video. Did you happen to take notes of which particular,
Yeah,
did you
but
write down which?
I did. But what I was going to say is the next one we're getting to, and I could skip it. If there's a chance that you can get that video of her or at least the audio of it, of her in the police department when she says, we all know that this is a joke, right? We all know that.
There's no way. There's no, like, I could do it, but it would be messy. Like,
Okay.
I'd have sound like interrupting you. It would be challenging. I'll try to do it while you're going through. So if you want to try to cover maybe some other motions, like, so I'm going to blow this up so that you can see it. So this is a list who, of course, was prepared by our incomparable Dizzy. And she, of course, broke down every motion that was filed by both the state, the Commonwealth, and also gave us the ruling. And now she had prepared this prior to today. So, but it'll give you a pretty good idea which one you want to deal with, so we can look and see what the exact title of the motion was.
All right. Well, the next one I wasn't going to even cover was one that was withdrawn, and then the one after that, the one we just did. So I guess 308 number 18, motion in limine relating to Karen's statements.
So 308-18. So the Commonwealth's motion in limine to admit defendants out of court statements as statements of a party opponent.
Right. So, and those are all allowed in. But what I was just asking Bob about finding is, so when they changed the charge, I think from what was it? I don't want to, I'm assuming it was something like vehicular homicide or something.
Yeah, it was a manslaughter charge.
Yeah, manslaughter. When they upped it to second-degree murder, Karen had to go in to get like reprocessed, fingerprinted because her charge changed. So when she is in there, she's unsolicited, says to the cop something along the lines of, "We know this is a joke, right? We know that he was beat up by," and she names whoever, and then she sort of scoffs like, "I hit him with the car. The back of my car threw him down. Come on." Something along those lines. And it's funny because in one of the earlier arguments, the state told the judge, she's admitted it. She said when she went in to get, reprocessed, I hit him with the car. My car knocked him over. And then like we went and listened to it and I was like, what is wrong? Like, hello? Seriously? Like, how do people get away with this kind of bullshit? Now, and don't take what I'm saying here because like I said earlier, like I'm still open to the possibility that, I'm waiting to see the evidence. Like Bob and I have talked. I'm like, I don't understand why that glass is still in his hand if he went inside. And, so who knows? But that kind of nonsense, that kind of like gameplay where you're being so disingenuous to take something that isn't what you say it is and say that it is, that kind of shit should not be allowed to stand.
All right,
Um,
let me see. I might have been able to find it. It would be miraculous because anybody who knows me knows I'm a absolute tech moron. So this could be it though. Let me
I
start
could probably have
sharing
done
this.
it actually.
Well, yeah, but you're far smarter than I am. So that wouldn't have been quite the miracle that I just may have pulled off right here.
So while he's pulling that up, they're not going to, and I thought this was a very good ruling by the judge because the video is super, super distracting. Now, yeah, I think it's a little bit forward.
No, this is a different thing. Let's see.
Oh, because it does.
Okay.
Here
Can you explain to me what the process is right now?
Absolutely. So you're going to be booked just like last time. Go through the same process. It's going to be a little less
Louder. Can you make it
time
louder?
consuming because we're not going to do major case spreads because we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time. We'll make a phone call. Your parents will be able to bring you whatever other
Well, why am I,
additional need, things that you need.
yeah,
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were, I'm sure you'll go over the charges again with you on the warrant.
but I'm on bail, so how can I be
Yeah,
spending the night here again?
all right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go?
Yeah, I'm just waiting for Ram to.
Okay. So, initially, your arrest was on probable cause out of the district court, okay? So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of the death. Okay, so those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in death. Okay.
Here it comes.
So bail doesn't apply anymore?
Typically, I'm not. So we don't set the bail.
Or almost.
Hold on.
about
I'm trying,
to.
I want to
This is
see
it.
if I know. I'm trying to get the captions up.
Murder comes into play, people don't get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian Albert. I mean, we're all in on the same joke, right? My taillight is cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine, we'll listen, but you were ready to do your rights, okay? And I'm sure he's gonna do it again. All right, if you want to talk to us, you want to give us a story, definitely. We'll take
No,
it.
I don't, I mean, I know you already know the story, so I don't need to.
All right.
So that
That it's time.
All right. So I'm going to play it one more time. Okay. Because what's significant is that what Allison was talking about is the way that Lally coached, or couched that was that thing she just said where, oh, the taillight was cracked. John was pulverized, where she's saying all that happened is my taillight's cracked. John, on the other hand, was pulverized because he got his ass beat in the house inside. He turned that into her making an admission that she hit John with the car. Do you see how he twisted that? I'm going to play it one more time just so we can understand how words can be taken out of context. All right.
I killed the clerk. I
Right,
killed the clerk.
It's classic My Cousin Vinny. I killed the clerk.
I killed the
No,
clerk.
I killed the clerk.
I killed the clerk.
I killed the clerk.
I killed the clerk.
Killed the clerk. Yeah, I mean, dude, classic My Cousin Vinny.
The rights that were afforded to you. So you can.
Right before that.
You got to abide by the rights that have
That are
been
afforded to you.
afforded to you. You got to abide by them.
A joke, right?
All right, so
That's it.
You can calm down.
no, I got to go back.
Right there.
Great jury.
Okay, you're aware he was beaten up by Brian and calm down.
Brian and Colin Albert.
I mean, we're all in on the same joke, right? My tail light was cracked and John was pulverized.
Okay, you need to abide by the rights that
Right,
were
that's it. That's all
afforded
she
to you. Okay? So you can talk if you want. If you want to tell us what happened, that's fine. We'll listen, but you were ready to do your rights, okay? And I'm sure he's going to do it again. All right. If you want to talk to us, want to give us.
You know the story. That's
So
what she says. I know you know. I know you know.
we're all in on the same joke, right? That's it's classic. It's scary. It's really scary, to be in that situation. And all right, so I'm going to pull these motions up. So that is what Allison is talking about. That exact statement. Now this video goes on for a couple hours, 3 hours, something like that. And so the question was whether or not they were going to be able to bring in her statement against interest. Now, there's nothing about that statement that was against her interest. I'm just here to tell you that was in no way, shape, or form a confession. No matter how you twist
I happen to think that the jury will be angry that the Commonwealth is trying to present that as though, I mean, to be perfectly honest, I'm surprised the judge decided it was a statement against interest. But
I mean, but are you really? It's like you're
I guess
sitting here
not.
saying that she made like she was fair on the things that I don't think are super relevant to the trial. In terms of the things that I think are, like the fact that there's a current FBI investigation going on with
Yeah,
regard.
that one I didn't think.
Well,
was
it's
it.
huge.
Yeah.
That's huge. Like I didn't give a shit about the rest of them. Like when she's barring them for all intents and purposes, other than to try to draw it out during cross-examination, it's offensive. If the purpose of trials is to get to the truth, then how can she see in any world where not letting the jury know that their investigation, law enforcement's investigation, was so poor that they, in fact, are investigating, the feds are investigating the investigation? You don't think that that's germane for the trier of fact to know? I do.
Yeah, absolutely.
Yeah, I mean, dude, it's like she may have, I think she was fair on some of them, but on the ones that mattered, I thought she sucked.
Right.
And that's just
Well,
my personal opinion.
so on that one, which I thought was a good call, she said no video, just the audio. And I agree. I mean, the video is just too distracting. All that matters is that they hear the words that are being spoken.
Right. And the reality is that the reason it's not the video, not because it's distracting, is because the defense was arguing we don't want to see her in cuffs. Okay. And she agreed with that. So it wasn't the fact that it was a distracting video. It's much like they don't want defendants being hauled in for their trial shackled and in a jumpsuit. That's why they always get to wear civilian clothes. It's the same concept. They didn't want to show a video with Karen Reed in handcuffs because it's prejudicial. So that's why. So at least At least she gave him that in a statement that shouldn't be allowed anyway, because it's straight up hearsay and it's in no way, shape, or form. It's just not a statement of a party opponent. It's just not.
Right, but I venture to think it should play in favor of the
If we have
defense.
smart jurors, if we
Right.
have smart jurors, you
And I
know,
think
it's like,
it's part of the culture there, like, that, they're suspicious that, like, there's been a lot of issues with official corruption and stuff. So I think, hopefully you get you're not gonna end up with a bunch of people who don't know. I mean, you're in Boston, like, people
yeah,
know.
yeah. Well, and she's relying heavily. Like she leaned in. I heard her say it a couple of times that she's going to give a limiting instruction. And do you want to explain to the people what a limiting instruction is?
Well, I think that was more for, and, we're gonna be that one we may have to do a whole separate, uh, live on the one that deals with getting in the fact that they were having domestic, or that they were having relationship issues, and, there's something that occurred in, well, why don't we wait till we get to that,
Yeah,
and bring it back up again.
that was defendant's 282. That was defendant's motion to eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence, which was directly relating to the Aruba New Year's Eve and angry voicemails. So that, because that's when John and Karen were beefing. I'm sure shit faced. They'd probably been drinking all day. It's like there's nothing worse than using like a drunk couple argument to try to convict somebody.
Right.
Jesus, I'd be in prison for the rest of my life if they had any of the recordings of my drunk ass arguing with you back in my drinking days. It's like,
And I don't think it's relevant because, at least from what we heard in the hearings today, and I did rewatch, so I think I heard everything, was that these voicemails were voicemails she left, she being Karen, after she gets home, and then whatever, if she slept, if she didn't, and she's now looking for him again. So in theory, in their theory, in the Commonwealth theory, she has already murdered him. So her state of mind at that point in time is not, should not be coming into play. It should not be relevant. And then, so that's where Bob's talking about a limiting instruction of, like, well, you heard this person be angry on voicemails, and, there was some fight that they had in Aruba. I don't know the full details of by any stretch of the imagination, but that she'll give a limiting instruction where you're not allowed to use this evidence to decide that because she left these angry messages, that she killed him, even though it's like,
right.
why else are you playing the angry messages?
Right. And the judge has all the faith in the world because she said it at least 2 times in this hearing that the jurors are smart. They'll understand. They'll understand the limiting instructions. They'll abide by
I don't
them.
even get it on that when this is the evidence you're talking about.
Right. Well, and especially because the entire theory of the state is that, or the Commonwealth is that they were done. They were on the outs. They were breaking up, that this thing was done. And she was furious with John because he was breaking up with her. He was ending the relationship. It's their entire motive, which we obviously know they don't have to prove. It's not an element of any of the crimes she's charged with. It's never an element, but that's their theory. Their theory is that, so yeah, it's like, it's one of those things that, like the only thing I take great comfort in is that we've got 3 really good attorneys, 2 really, really experienced, really good attorneys who are going to be able to clarify things in closing arguments. And, that's the only, that's always kind of like the safe harbor for me in terms of adverse rulings by the judge. I mean, you and I as defense attorneys know,
I've had it a ton of times.
it happens
We
all
had
the
a
time.
judge on our in Kane County. That's the county where we're primarily in when we're, well, in any event, our very first trial that we won, the judge huffed, stood up, and left the left the bench, just up and walked out of the room, like, And then I had a federal trial once where the judge was just so, I mean, it was crazy. So so against the defense. Um, she was so angry after we got a not guilty. Who won't even going to get into everything that she did. But I said to Bob actually last night, I said, you know what? I'm wondering, do you think it's possible that this judge denied the motion to disqualify and has made some really like state good rulings for the state because she might be planning on dismissing this on a directed verdict, meaning like after the state goes and they put on all their evidence, the defense gets to say to the judge, well, Your Honor, that is not beyond a reasonable doubt. Like no reasonable jury under the law could find that to be reasonable doubt because we just heard there's a whole nother possibility that's equally plausible. Like this is not beyond a reasonable doubt. And this is in my mind. I'm thinking like maybe that's in her head. Like, well, I'm going to let them do everything. I'm going to let them have everything because you know what? If it's what they're saying if it plays out the way the defense is saying it's going to play out, I'm going to nip this thing in the bud on a directed verdict. And then today came and I was like, definitely not.
Yeah,
Like
it was
you could tell the disdain she has for certain positions the defense takes. You hear it in her questioning, you hear the way she comes at them. She's definitely not a fan of this defense, a fan of the defense team. But again, in certain aspects, she's still being even. And there's other things that, maybe she's not, but you
I
can
mean, she has
definitely.
to be cognizant of the fact she can't be overtly, like state-sided because like she's not trying to get this thing kicked back on appeal, like on the direct appeal because she screwed everything up. I mean,
She could on this whole not assigning a different prosecutor.
well, I think without question, if the argument of two wrongs don't make a right is all the state's bringing, which is exactly what his argument was by way of them continuing to make, them having the little 9.5 minute, hit piece on the
He
on the
said the
state's witnesses.
words. This was primarily he basically he literally came out and said it. This was really in response to the 100 people that Aiden had gathered up that were protesting and, telling this group like, we know what you did and, you should come clean, which has nothing to do with the defense. It's not the defendant. It's not the defendant's counsel. It's not in response to anything the defense did. So luckily he switched gears there and pointed out something the defense actually did, the day before. I don't know how if you talk about disingenuous and you want to be fair about it, I don't know how fair it was for him to say, and we largely, complied with this court's ruling. And then we hear about 9 minutes where they're, you know, putting their entire, theory out there. Again, but like Bob
Yeah,
said,
but you can't go out and improperly bolster your witnesses in an
there's
upcoming
nothing about what he did that
No,
if he's
there
not sanctioned for this afterwards. By the way, in our ethics, the prosecutor's ethical responsibilities are above everybody else because of the power that they hold, because of their position, so they've got higher ethical standards that they have to live up to. What he did there was the most outrageous thing I almost have ever seen.
no doubt. Like I've never seen anything like
Well,
it.
you've seen some fireside chats.
Yeah, I mean, even but it wasn't like that.
Yeah, no,
Like
that was bad.
his fireside chat was not that. Like that, it was bad, But he was really just kind of talking about, how guilty our guy was. He wasn't talking about like, how credible Cecilia Hoffman is. Then that she's an amazing person. She's changed her life, and every word that she says that comes out of her mouth is like spun gold. And you could just complete. It's like it wasn't that. Like I've never seen anything like that. It was
Yeah, that was
crazy.
outrageous.
All right, so why don't you cover another one? What else was there?
All right, so the next thing they did is they jumped to discovery issues.
Yeah.
And so apparently the statute or the criminal procedure in Massachusetts is the defense doesn't have to their obligation at reciprocal discovery to turn over their stuff doesn't kick in until the state is finished, which is the way it should be. And so apparently the state didn't do that until I'm not sure of the date, but then the Commonwealth told the court that it took them, like it was still 5 days after they had turned their stuff over and still they had nothing from the defense. And it's also just as a part of courtroom decorum, a lot of judges are very strict with it. One lawyer talks on one issue, period. So what's his name? Linetti, Yannetti,
Yannetti.
Yannetti
Yannetti.
was speaking. So he told the judge, well, I'm sorry, I'll make sure I get the state whatever it is they're asking for, today or whatever. And the judge says, we had this. She's getting real snippy. We had this discussion, and I told you, I expected you to get it to them within 2 days of them getting it to you. Why 5 days later, they don't have it? Rar, rar, rar.
Right.
And then the other co-counsel that they have, the young woman lawyer who Bob mistakenly said was Melanie Little. I'm not sure if we know her real name at this point.
Eliza Little. I think
Okay.
that's pronounced Eliza. It's
Doolittle?
Eliza. No, not Doolittle.
Eliza Doolittle. Got it.
No, not Doolittle.
I know, but do you know who Eliza Doolittle is?
I'm assuming the wife of Dr. Doolittle. Is that
The
is
rain
that right?
in Spain falls mainly on the plain.
Is that from Dr. Doolittle?
No. All right, let's move on.
Yeah, I'm not.
Um,
I'm not a musical guy. All right, so
But in any
before we move
event,
on-
she's
hold on before we
Okay.
do that. Like Kay was asking this question. So this heard about this theory of the undercarriage potentially causing the damage to John O'Keefe's arm until like yesterday or the day before. It was the first time I ever heard of it. I don't know. I would assume if that was their theory, that they being the state, that we would have heard of
Phoebe
it at
knows.
this point. I don't think so. Oh, Phoebe. All right, dude. What you could have just said Phoebe knew. Because I was trying to read through that. So you know what she's talking about, right, Allie? I was talking to you last night that this theory that's kind of popped up that
Okay, sorry, I took her thing down. Sorry, yeah.
right, the abrasions on his arm could have been caused from him hitting the muffler or scratching his arm on the muffler on the undercarriage of the vehicle.
Right.
And so she was asking if they've done DNA. I don't think that that's their theory. Like, they have never given us what they thought the abrasions were from, which is very mysterious. So I don't know the answer to that, Kay. I don't know if they processed it. I'm guessing no, because the likelihood, like from what I've read, there's an 8-inch clearance on that. If you try to think of like the biometrics that would have to take place in order for John O'Keefe to be laying flat, like after he's struck, and then like pancakes like immediately so that he's laying flat, and then his arm is up. Like I don't think that thing holds. Like, that whole concept does not hold water for me. So Kay, John's clothes were thrown on the hospital floor, then carried.
Sorry.
All right, let me pull stuff
Sorry.
off. You're too quick on the trigger. Were thrown on the hospital floor, then carried around in a car for weeks before it was ever turned in for processing. The clothes would have told the tale. So, I mean, look, this is all the stuff that's going to come out at trial. In
It's
terms
something
of
the medical examiner would have wanted to see.
for sure. Well, it's like my first question is like, okay, well, what did John O'Keefe's sleeve to the gray sweatshirt he was wearing look like? Like,
Right.
did it look like a dog had shredded it? Did it look like he was dragged on the road? Like, the clothes are going to tell the tale, because my biggest problem with the vehicle striking him concept is, where are the injuries on his torso or legs? There's nothing anywhere on his torso or legs. It's completely inconsistent with being hit by a car. Like he would have had to have gotten struck somewhere else, unless you're going to say, like I saw like months ago, somebody had made a video that he had gone into the middle of the road, put his cocktail glass that he had taken from the waterfall down in the middle of the road, and while he's bending over, that she backs in, and that's what causes this huge contusion on the back of his head. It hits him right on that. It seems like that would have broken his neck,
Right.
like that kind of. So I don't know. Like all this stuff's going to come out at trial. I cannot wait for this trial to start. I cannot wait for this trial to start.
Yeah. So in any event, I was starting to say that while the judge is getting snippy with them about that, the Eliza stands up and the judge begrudgingly allows her to speak, and she says 24 hours after the state gave us their disclosure, we sent reciprocal discovery with all the statements we have from all the witnesses, with their addresses, with their information, sent it all to them. And then the Commonwealth responded that there were 77 witnesses listed. 35 of them are the Commonwealth witnesses. So obviously the defense doesn't have to do anything when they're saying, I might call your witnesses, and that he only got 4 reports with statements. And then Eliza pointed out that there were also 10 that are in the federal material. Now the judge says, I want you to identify the page of the federal, material, which seems somewhat unusual, but okay, so be it. Um, and then they moved on to experts. So I don't know if there's a corresponding, because the judge didn't give the number there, but the state's trying to say that he doesn't think that their experts are qualified to give the type of opinions that they're going to give. And he's asking for the experts to be voir dired beforehand. And the judge is saying, well, give them the material, what they want, so that we don't have to do that. If you don't, we're going to voir dire them. And that, it just turns into a whole little mini thing outside of the presence of the jury. I don't know why they didn't do this kind of even sooner before this, like a motion to exclude. Maybe they just got the information because of the fact that they just turned over their information. Part of it was a biomechanical reports, and the judge was taking issue with the fact that there were 3 experts who signed off on the same report, but that nobody had identified which expert did which, and she wanted them to explain it more thoroughly. And she sort of chimes in there, and she was like, well, on their CVs, did any of them have accident reconstructionist background? And the Commonwealth sort of jumped on that and said, yeah, but we don't think they're actually qualified to give those types of opinions. So that's sort of where we left that. Then she got into how each side could have 45 minutes for their openings.
Right.
Neither side's going to use visual aids. And then she again discussed what they call the Bowden evidence. That's the third party culpability. Some other guy did it, that the defense is not allowed to mention it in their opening at all. And then we go to 319. And she didn't give a number on this, but it's about cross-examining and bias and.
Let's see. So what the heck? Hold on. Let me try to slowly move up. Oh,
Yep, you did
so
it.
annoying. I just wanted it as like one.
Got to make it a little smaller. That's why.
Oh, I see. Okay. You're so smart. Okay. Oh my God. Smaller still?
I mean, you shouldn't have to be smaller still, but now will
Okay.
it let you blow it up and keep going up?
Yeah. So 319. That is okay. The Commonwealth's motion in limine for advance notice if defendant intends to cross-examine any witness about alleged bias and request for pretrial ruling on whether the proposed evidence demonstrates a plausible showing of alleged bias.
So
That's quite a caption for a motion.
Right. So what she ultimately said is that you'll take it as it comes. If there's something that comes, object to it, and we'll see. She wasn't gonna rule in limine that the defense was limited, and she can't. It would be a huge constitutional issue. Your right to confront witnesses is one of the strongest held constitutional rights that a defendant has. If a judge wrongfully limits it, you're allowed to point out anything for bias. And um so like, she made the right decision there, but we won't know until trial if she's actually ends up making the right um the right decisions, because it'll depend on the questions. um, and you can tell from when we get to the end, one of the last things that they kind of touched on, I mean, she already doesn't think, I mean, we know she already doesn't think they've reached the threshold to get third party culpability evidence in. And in my mind, they have shown a very, very direct, clear, it's like, I almost don't think you could get a more clearer argument for third party culpability. They've got motive. He's at their house. He's in their driveway. There's an expert who says that these are, more consistent with a fight. It's just kind of
Right, but on the other side, you have their ME who say that it's inconsistent. They like none of the injuries are
well,
consistent with
but
any
it doesn't
kind
have
of.
to be beyond a reasonable doubt. It just has to be, well, I don't know, maybe you've got an
Well, she's letting it in. I mean, she's gonna let it. She's gonna let the third party culpability in. But as
she
you
hasn't
stated,
said that yet.
oh yeah, yeah, she
No,
did.
she said she'll let them cross-examine on bias. That's very different.
No, no, no. She said she's gonna allow them to
Then
get third party culpability in, but she's
then
gonna
why
make
aren't they
them.
allowed to put it in the
She's go-
opening?
because she needs to see it proved up. It's gonna be.
Right.
She's going to
Well,
allow them to entertain it,
that's what
and
I'm
she's
saying, that
gonna.
I think she should have found it from their offer of proof that they've had
I
enough.
agree.
Right.
Obviously,
But that's what I was saying. You have this lawyer who's a Massachusetts lawyer in here. Maybe she's got some good insights. You said Melanie, right?
Yeah, I
Well,
don't know.
Melanie, if you
I
got
don't know if
anything and you're still
Melanie's still
here,
in.
you can chime in. We'd
She may have
love to hear.
bounced. It's
Yeah,
it's
it's
late.
late.
It's late for her. Yeah.
It's late for everybody.
11:30.
Huh.
So the other thing that I thought was interesting was the 318, which was the other adverse ruling that just infuriated me. And that was the Commonwealth's motion to eliminate or prohibit reference to any pending internal affairs investigations or unfounded allegations of misconduct. And that related to Proctor and the victim's advocate. Now, the argument that Jackson or Yannetti made, I can't remember which one it was that the victim's advocate had made, I think it was Yannetti, had said that this victim's advocate had told Brian Higgins that he should get rid of his phone. Okay. And a victim's advocate, if you're not familiar with what their role is, it certainly isn't to be talking to independent witnesses that the state's going to be calling that are not victims and telling them to destroy evidence or to get rid of their phone that may contain evidence, whether it be inculpatory or exculpatory. It doesn't matter. It's not the place for that to happen. He's not the person to be having those conversations under any circumstances. And the second part was the Proctor issue, that Proctor is currently under investigation. He's got an IA investigation going, and they wanted to be able to bring it up. They think it's
She did
pertinent.
not say no. She absolutely did not say no.
She didn't say yes.
Well, right. She said that, well, here's what she said. So they said they wanted no reference to an internal affairs or any unfounded allegations. She said those are absolutely fertile cross-examination questions, because it doesn't matter if they're sustained allegations or they've even finished it. The question is, like, is there someone investigating you? Could it take your job? But she did say she wanted some more information so that she could decide. And I could tell at the end, like, where she kind of fell overall, because she made a comment like, maybe we let it get in that there's this investigation and we don't tell them what it's really about. And I'm thinking, are you effing kidding me? Like, don't tell them what it's about. But here's what
But
I
defeats the entire purpose, because the entire purpose in terms of, because Lally flat out lied during the hearing.
right.
He said that there was no IA investigation against Proctor, flat out lied about it to the court, which was so bizarre. It's like she can read the documents and see what's what. It's just strange that he's doing these things.
So wait,
But that was another thing that she said that they cannot bring up in opening.
right. So here's what happened. So this Commonwealth said that it's unfounded, that it's not even like it's like it's having a civil case with no judgment. And the judge went on and she's like, no, even if there's no finding, why can't they cross-examine on that? And then he also said that, well, they're acting like one Albert equals the whole family. And the Albert that's at issue is not even relevant because they have this situation that they want to talk about that took place a long time ago, but where this one sergeant like stood up or got in a fight or something for one of the Alberts. And they're like, well, but it's the brother and then that's the son. So we're not talking about that many removed Alberts. But she said that so the Commonwealth said that they didn't think it was relevant. The judge says it can come in if it's relevant to bias on cross, and and she wanted to focus on this McFarland and Graham. The cases that they were citing were more discovery issues, not admissibility issues. And so the point that they were making, sorry, because my notes are long, was they turned back to the whole Albert issue, and he was like, well, the long-standing relationship with the Albert family, and then the judge says, well, as far as I know, the Albert family is huge. Like, she chimed in with that, and the defense went on to say that, like, Chris Albert is Brian Albert's, and that's where I didn't get it, I think brother, and then that Colin is the son. And that they can get this evidence in through Lang himself. If he denies it, then they'll go from there. And she said that to inquire about the family is okay, but the incident that's unfounded with Chris, we're just going to have to see how it develops. And we may have to voir dire Sergeant Lang and Chris Albert on this. Because what they were talking about was like, if he can get it in, if the defense can get it in through someone other than a prosecution witness, like literally calling an employee of the prosecutor's office, that's what they have to do. They're only allowed to call like a prosecutor or someone from the office if they've got no other way to get the evidence in. So they were kind of talking about that. And she basically said, we may have to voir dire him. We'll see how this plays out. But she said, let's turn to Trooper Proctor in regards to, oh no, that was Trooper Proctor in regards to the internal affairs. That the investigation, he's trying to argue the investigation wasn't appropriate. And so they said that this is what the Commonwealth was saying. As far as I understand it, they were saying that the paperwork the defense is referring to was actually the district attorney's office interviewing these officers to do like a bias background. Like they asked internal affairs to like do this interview to determine bias. But then what it sounds like happened after that is internal affairs actually started investigating. So the judge took it again. Like when she repeated it back, she was like, yeah, but you're talking about an internal affairs investigation that was started by the district attorney's office. And I don't know if she's left with that misimpression, but I thought he being Lawley sort of was like, well, no, that's kind of two different things. There was like, we asked them to do this bias interview, and that's the paperwork they're talking about there, but there's also this investigation and we don't know what it's about. And that's, like you said, where the defense jumped up after and was like, called bullshit again, on saying that. So it says that the judge says, why isn't the fact that there's an ongoing investigation that he's subject to, why doesn't that go to motive or bias? So, which she was right on that. And then the Commonwealth responded that the investigation could go nowhere. We don't know what the investigation is even about. And Miss Little says, that's extremely disingenuous, Judge. Oh, that's extremely disingenuous. And then the judge says, why? is there something that you have received? And the state said yes, and the judge asked for a copy of it, and they said that they would give the judge the copy of it. And they requested and that they found this when they requested the disciplinary records, and it was granted. And then the judge chimed in again, granted, because the Commonwealth didn't object. So it's
Right.
like those kind of things when she's chiming in that shows you
Tells you
she's
all you need to know.
right.
Tells you all you need to know.
Exactly. She's still staying on that side. And then the defense goes on to argue that they received material showing that it was an investigation. And again, this is when the judge chimed in again and said, well, it's an IAD investigation that was requested by the DA. And in my notes, I wrote, it sounds like two different things. And then the judge says, um, and they're like, but this is an investigation of the law enforcement who is in charge of this investigation. And then the judge chimes in again and says, but with other people, right? I mean, he does this with other people who are involved as well. And the defense responds, well, he was the lead investigator. So again, it's those kind of comments by the judge that shows you where her mindset is.
Yeah, but like the whole thing with like Morrissey and that presser where he's just flat out lying, saying that the Proctor wasn't at the scene. It's just, I don't like, because here's the issue that I have with it, with the case. All right, because people are so dug in on both sides of this that if and when she's found not guilty, which based on what I know, I can't see a world in which she's convicted. The problem for Karen Reed is that all the people on the other side of this that believe that she's guilty, she's never going to be able to live a normal life. This isn't a situation where, unless the judge allows for them to really delve into the third party culprit defense to the extent where somebody beyond the prosecuting office that's currently prosecuting this case takes an interest in it and says, okay, we've seen enough. We're moving on other people. This is going to be something that is just going to follow Karen Reed around in perpetuity. It's like the same thing that I'm always talking about with Alan. Like if they limp out of there with an NG based on, that they couldn't meet their burden, that's not the same. It's like that old thing that you hate to hear judges say to your client, that just because you were found not guilty doesn't mean you're innocent. I mean, that thing is a life ruiner, and it's something that haunts. Like, that's why, to me, they have to really be able to dig into this. I mean, if you look at their witness list from head to toe, it is the people that were in that house, and I'm talking about the defense, the people that were in that house and the cops and some experts. And that's it. Like that is their witness list. And of course you got Lucky Loughran, the plow driver and stuff like that. But the bulk of it is them trying to make their case as to the third party culprits. And I'm just fearing, based on like the little things, like you said, like those little things that she sneaks in there, those little snide comments that she makes. Oh, well, yeah, no, it's because the comment, like when he said you granted it, it's because the Commonwealth didn't object, implying that she wouldn't have granted it.
Right.
I mean, it's like, I'm concerned going in, and you've got two guys that know exactly how to get this evidence in. What's up, Blair? Would you guys say that the prosecution calling John's minor niece a risky move as far as how the jury might take it, or even an act as of desperation? Yeah, I don't know how the jury will. It depends on whether or not Lally's able to couch it right.
Right, because clearly it wasn't like the way the Commonwealth is presenting it. Like he said, I'm breaking up with you. I want you out. And she refused to leave. Meanwhile, they're out together as a couple. So it's clearly not that black and white. And I don't think that the defense is going to be disputing too much that they were, like that there was an argument or that she was upset that he was staying or whatever, whatever happened. But it's just going to be really far fetched for someone to believe they did what she's describing, as opposed to like she was drunk and she accidentally hit the guy. They might have been able to convince a jury of that. But when
Right.
they come in saying she moved forward 21 feet, she gunned it and murdered him and left him and then called, getting angry at him for not answering her calls, and then putting
It's a
on
classic overcharge.
Right.
Like if that doesn't happen, Alan Jackson's not on this case. You know what I
Right.
mean? It's like when that second degree murder hit, that's when shit gets serious. Not that the underlying charge wasn't serious either, but like if we don't get to this point, does this even get sniffed out? I mean, look, any attorney, any defense attorney that was handed this file, whether they were private counsel or even a public defender that looks at it and they're going through the police reports and they're like, well, where's the police report where they go into the house of the yard where they found the dead guy? Like, did you forget to send those to me? Because
Right.
I know they went in, because there's not a world in which somebody who has a dead person on their lawn that was supposed to be going into that house, that law enforcement isn't getting a warrant to go in and sniff around to see if something went down in there. Unless, of course, you're a bunch of cops. I mean, just it reeks of impropriety on its face. It just seems like it's just like it's rotten.
And I'm gonna interject some also fact-ish, not facts at all, but from that guy that we listened to last night, former Boston cop, former FBI, 30 years. I mean, he goes
I
as
think
far
his
as
name's Sean McDonough, I think.
all right, well, he goes as far as to say what he thinks happened is that John or someone in the Albert family took out their little book and he's describing it like this is commonplace. This everybody's got their little book of who they have done favors for. Who did I,
Who
stick a
do I owe?
wiretap? Right. Who did
Right.
I
Who
stick
do
a
I
wiretap up for some political campaign? I think was one of his examples. Who
Right.
did I cover up something for?
Yeah,
And
who do I
that
owe? Who do I
right.
owe?
Or who
Right.
owes
Or
me?
who owes
Who owes
me?
me?
Right.
Right.
Either way.
I have no idea if that's true at all. So I'm just saying I found it odd, or not odd. I found it, you know, surprising that this is what a man who's dedicated his life to law enforcement is assuming happened, that somebody's busting out their little black book and saying, if I go down, you go down. That's the words that he spoke. Um, but I don't know. And I think what we were trying to ask you, Melanie, before was about the voir dire process, because the judge seemed to hold it out like, if you don't figure this out, we're voir diring these people. Like,
During trial.
right. Like if there's something kind of more to it, or she just knows how that breaks up the flow of a trial, or kind of why she was sort of holding it out like that. But yeah, the judge, I didn't like her comment at the end, because she was like, well, but if it's something that he could possibly lose his job over, and what I wrote here is that she said, well, we're gonna figure out a way to limit it. Maybe we just tell them about the fact that there's an investigation. So, and like we were saying, that to me doesn't seem at all, you know, like enough. But she kind of hasn't decided it yet.
Yeah,
And
and look, I mean, it's not it's not bizarre for a judge to say we're going to take a wait and see, approach for some motions in limine relating to certain evidence to see how it develops during trial,
Yeah.
but like as far as the IA stuff and the FBI investigation and her just stonewalling them on that, to me is repugnant.
it's
Like,
gonna be
in
that
the
will
search
be
for truth, it's got to come in. It's
it's
got
a
to come in.
it's an unconstitutional limitation on his right to cross-examine. It absolutely is.
100%.
Like, I
100%.
can't I would be shocked if that wasn't reversed on appeal. Now, judges can do whatever they want at the end of the day, and they put a lot of discretion into the hands of the judge to limit cross-examination when they think that it is going to be prejudicial, not probative. And, so there's always possibilities, but I can't imagine, to me, in the same sense that I was kind of surprised she didn't disqualify them, I can't imagine that the fact that there's an open even if you just left it to the aspect of this investigation was so bad that the feds are investigating your investigation
Right.
without even getting into what the feds think or who their, what their theory is, but just the fact that that's the part of this they're investigating, that part of this, that she doesn't think that that's relevant, because when you're reading a lot of appellate cases, Supreme Court cases, I mean, that's the one of the number one things they say. Well, the defendant could have used this information to discredit the investigation,
Yeah.
to completely discredit the entire investigation by challenging and impeaching the police and showing that these officers have done things wrong in this case, in other cases, to impeach the entire investigation. And that is always a very large aspect when they're trying to decide on appeal, whether there's what we call a Brady violation, like that's where this comes up, or if the judge limited cross-examination in a way that it shouldn't. They're allowed to impeach on bias, and there's supposed to be a lot of leeway, even though a judge does have a lot of discretion.
For sure. And so this was another one of those moments where you got to crawl into the mind of the judge in terms of where she's at, when the entire thing, when they're talking about Proctor and she asks, how are you going to get it in? And they say, well, Proctor.
What if they don't call them?
She says, what if they don't call Proctor? Like, so to answer your question, Jeff, I've never, ever had a case where the lead detective or investigator that handled the investigation is not called at trial unless they die, and then they can rely on, like other cops under, certain doctrines. But no, like when she said that, like when she said it, it reminded me of the scene from The Verdict, which is one of my favorite movies of all time. It's obviously a civil case in that. And if you guys have never seen The Verdict with Paul Newman, it holds up. It looks a little aged, but the story's unbelievable, and Paul Newman's phenomenal. And it's regionally speaking, it's very appropriate because it's a Massachusetts based story. But it's like where Paul Newman, the judge keeps asking questions of a juror or of a witness while they're on the stand, and Paul Newman's like, well, if you're going to argue my case for me, judge, can you do me a favor and not lose it? It's like the things that she does, like I'm almost like every time she does something like that scene from the movie pops into my head, because she has a real tendency to interrupt the state, like not the state. Like I never hear her interrupt Lally, but I hear her interrupt Yannetti constantly. I hear her interrupt Jackson constantly. It's just those little things, that you see that kind of rub you the wrong way and really make your hairs bristle up, and it's like we're searching for the truth here, like that. Like everybody wants justice for John O'Keefe, and the only way that goes down is by figuring out who the hell did this. And the only way that happens is by letting it all play out, whether she likes it or not, and it's like, so, you got anything else you want to talk about? So,
Yeah.
Apparently Melanie is gonna do what we were gonna do tonight, tomorrow. So I'll definitely I'll definitely come check that out. She's going to go through I think she's going to play the actual hearing today. So
Well, you did that this afternoon. That's why I didn't think.
yeah, but we weren't handling it really from a legal perspective, because I wanted to hear the hearing, and we switched right over to Daybell to cover that trial. So
Right.
we didn't get
All
to
right.
give
So
any kind of
the next
legal
thing that
note.
they go into is the blood draw. So that's the blood draw of Karen to determine her blood alcohol level. And the defense was arguing that it wasn't done in an accredited manner per Massachusetts law, that it was an unaccredited blood draw. And then the judge chimes in, if all the witnesses are here, doesn't this go to weight and not admissibility? Which is probably a fair point. And hopefully when you guys see Melanie tomorrow, she can give you some more specific state law. But the defense responds, well, we think it's important enough to not be trustworthy, to be so overly prejudicial that that it shouldn't even get in. And then the judge says, wait, this was taken at the hospital and tested at the hospital. Isn't that what we do? What happens in this state all the time? So if the hospital's lab is irrelevant because it wasn't the state lab. And then the defense says, well, one element in the problem was the extrapolation. And he starts to try to explain it. And then the judge says, I know what it means. Like, she's like, you're going to mansplain this to me. She chimed in. I know what it means. Um, and he continues on to say that it's so unreliable that you can't unring the bell. And the judge says, well, sounds like perfect cross-examination then. And
Yeah.
he says, yeah, but if you could save me my breath by excluding it, then, and that's sort of how that ended. And I do think there probably is issues like that. Like if you see blood draws that are done in the hospital that aren't by the same standards of what we use when we determine the blood alcohol level for like a DUI, and it's
Right.
sort of different. And if they don't do and I'm not going to think of the right words right now because I tried to not do the DUI. But the way that they determine the blood alcohol level isn't by the same way that like the statute sort of calculates it. I have made that argument in cases like, well, wait a minute, we can't really determine, how are you determining that that equals, translates into this blood alcohol level when you use the analysis that you're supposed to use. But the judge's point's like, well, we do that all the time. That like happens all the time where the hospital
Yeah, but
takes
that's
it.
in a DUI, not in a murder case. And like Jackson's point was like, look, like that you can't unring that bell. Like yes, I can cross-examine them about how they didn't follow protocol at all, and it shouldn't be given any weight as evidence. But that's not how juries work. Juries hear the number, and then the extrapolation on that thing was insane. Because like they did the blood draw like at whatever time it was, 6-7 in the morning or maybe later, and it's like it's just above or right below the legal limit, like 0.07, 0.08, and when they extrapolate it, they have this huge range, like from 0.179 to like 2.89. It's like, it's crazy, so his point is it shouldn't get in at all, and she's making an argument relating to DUI cases. Well, this is not a DUI case. You know what I'm saying? It's like, that was just another thing that really, really pissed me off too. And like kind of the final thing that like really pissed me off, like really angered me, was the whole AV thing. It's like, we were trying to explain during our live. I'm like you and I, like struggling through our entire careers, begging the state to use their shit to play our evidence is annoying as hell. Like they get to roll their stuff in because we've been practicing so long. It was back in the days where they'd come in with rolling their cart with an old school TV on it, a VCR, and then it went from a monitor to a laptop on there, and and it's like, oh, can you help us with like, I don't want them touching my evidence. I don't want them helping me. I want to be able to put my own evidence on, have my own guy have my stuff queued up, so there's a flow to it. So it's not some kind of awkward thing going on when I have a witness on and the state's like, fudging with it. so that I completely lose my flow during my direct or across, whatever the case may be. I mean, like her whole thing with that, like asking the person who like works the AV for the court, like, can you make some time? It's your job. Make time. You're gonna have to make time for the defense in order for they've got somebody who's gonna make the trial run smoother for all of us. It's gonna make everybody's life, like that whole thing.
Well, I've had that same
Really bugged me.
issue. We've had that same issue in a trial where we decide that, like, we are putting into evidence, and the judge is like, "Well, what happens if the jurors want to listen to this? How are they going to listen to this?" I was like, "I don't know. I could, bring a laptop or something." She's like, "Nope, they're not allowed to have any Wi-Fi access. It can't have anything else on it." You know, and I'm like, "All right, well, the state does this all the time. Why don't they bring in the computers they use when whatever special computers they have?" And the judge is like, "State, would you be willing to do that? Would you be willing to let us use your computers?" It should not be
That's what
like
I'm
that.
saying.
It
I like
should not be like
Right,
that.
it's ridiculous. Like the state has all the power, all the money, all the resources already. And like when you're beholden to them to try to get your evidence on in a highly technical world that we live in now is absurd. It's like I mean, their office is in the courtroom or in the courthouse typically. Like every advantage that they can have, they have.
And what about where their desks are
Oh
from the
yeah,
stream
that was
today?
the other thing,
Well,
Melanie.
can you pull
So
up the stream just like
everyone like so like the way that it's set up, at least in the courtroom that it's no longer going to be in, was that the state's table, it seems like it's almost connected to the bench, and then
with their
they have
backs turned to the defense?
and they're standing in front of the defense. Like, is that what it's like in
Melanie, that's what we
Massachusetts?
wanna know. At
Yeah.
trial, is it gonna be different and they'll sit side to side like
Or
in
is that
every other.
commonplace for Massachusetts in general? Like, is that how they set it up? Like, because here in Illinois, it's like we're side by side, like
Right.
most normal places are.
I've never sat in a courtroom like that ever. I've been Philadelphia, New York, here, Indiana, St. Louis, Nebraska. I mean, I can't even think of there's, Delaware. I've never ever seen anything like that.
It was crazy. I've never seen anything like talking about like prejudicial. I mean, it
Absurd.
just gives you the vibe that like the table literally looks connected to the
To the
bench.
bench. Like he's part of the judge and the judge is
Right,
part of
right.
him.
Like they're all just the government,
Right.
which they
And
are.
their back is to the defendant.
I mean, it's accurate because they all are the government. The prosecutors, the judge. I mean, they're all government employees. They're all paid by the government. The new
Yeah,
smaller
but that's
courtroom
not
will
the
only have
question I
enough
wanna know.
gallery space. No, we're talking about how the council tables are set up, Melanie.
Right.
Like in her courtroom, it's set up where Lally and the crew is standing there right in front of the bench because their table is either connected to the bench, that large structure, or it's pushed up so it's flush with the bench, and then they're standing in front of defense table. We've just never seen that. That's not how it is in Illinois. It's like I've never
Oh,
seen it.
she answered that earlier, uh, in New York. So she's not in Massachusetts, she's in New York.
Oh, okay. All right. Yeah, I think that's crazy. Like if there's anybody who's familiar with Massachusetts courtrooms, let us know if that is yeah, that setup is whack. I mean, it's prejudicial. It gives the prosecution, it gives them more credibility in the eyes of the juror because they think that they're in tight with the judge. Oh, well, look how close their
Look
table
where
is.
they are. They're
They're
part of that judge.
special. They're so special. Yeah. Yeah, I know. Like I wasn't thrilled about it. It's like that. It's that old axiom, be careful what you wish for, you might get it. I'm sure she
So
was happy to keep everybody out of the courtroom aside from the family and the press.
yeah. So you've got then they did the 306 expert Cellbrite demonstration, which was allowed. It doesn't really seem like there was any. I can't remember if they objected actually. And then it went into the Commonwealth wants no reference to the internal affairs investigation, which we already which we already covered. And then it went into, yeah. And then, oh no, right. So then it went into the DA's testimony. So, but
Do you have a
we
number?
started to cover this. It was, hold on, blood draw. And then Paul O'Keefe, 293. No, that was exempting him from the sequestration, the
Yeah.
father.
Yeah.
And then I didn't get a number for this other one, but it was basically what you kind of brought up earlier. It was a two-part motion. They wanted an offer of proof about calling the prosecution team. So this was that they might want to call like the DA and question them about whether the Canton police were going to be, and the victim advocate. So we kind of touched on
Yeah,
that.
we touched on that.
Yeah.
That was the whole thing. That was, that was where the victim advocate's telling them, yeah, get rid of your
So this was some of the other things, right, that the judge chimed in, where they were arguing that the victim advocate told them that let's see. So what I have here is that's where they were talking about how if you can get it from anywhere else, they don't have to call someone from the prosecution team, and that the DA testing about, purported issues about removal and the Canton police. So sort of like what happened where gosh, it's getting late. Did he do it guy? Did he do it?
Did he do Stephen Avery?
Avery, where they said, "No, this police force can't be covering it. We've got a conflict here. Let's bring in this other police force." And then, the Canton police were removed, or there was some limitation, but they still stayed
They're still
primarily
creeping around.
right. They still stayed primarily involved. They were still conveying information to the sergeant or officer that has the relationship with the Alberts, and the Yanetti's saying, like, we may only be able to get this in, like, through the DA. And then he talked about how the victim's advocate, who you talked about before, having a professional relationship with with the witnesses. And then the judge said something like, you mean like you always had a good working, like you worked very closely with your victim witness advocate when you were a prosecutor, and he was like, well, yeah, that's how I know
That's
that
how I
this
know
is
this is so
right.
improper,
This is
what this guy's doing.
this is the way it works.
Okay, yeah, because
Um,
Brian Higgins isn't a victim.
but no, they said he also deals with witnesses for the state.
Okay, well,
Or he's a
that is
victim
that is not the role.
advocate witness.
And witness concierge.
He called him a witness victim advocate.
I never heard of such a thing.
And then the judge asked, well, when witnesses are getting harassed, is that the person that they call? And he's like, absolutely. And right. So then I've got where then she says, so when you were a prosecutor, you worked closely with the advocate. Yes. But, he had conversations with Higgins. That's one of the witnesses. And that he was asked, where his cell phone was. And are you aware of the preservation order? And that the victim advocate said that he could get rid of his phone. And then the judge says, I don't think he said, or that he could destroy it. I don't think he said destroy. And then he was like, oh, I'm sorry. It was that he could get rid of it. And then the judge chimed in again, could or should get rid of it. And Bob and I both look at each other like, I'm sorry, is that a distinction without a difference? Like that
Right.
the judge is pointing out and thinks she's making like a drop the mic kind of point. He said you could get rid of it, not you should get rid of it. Wait, are we not upset about whichever way that
Isn't it
happened?
improper both ways? It's
Yeah.
improper. There's
But
no
then the Commonwealth says none of that's accurate. All he did is tell him,
Yeah.
hint, hint, the preservation order's been lifted.
Yeah, it's like classic, and everything that guy just said is bullshit. It's like that
Right.
move, it's like there's no real legal argument. It's just like, everything they said is bullshit. So everything that they just said is a complete and total fabrication. It's like
Right.
that's always his response. It,
So
it,
they
it
let him know that the Commonwealth was saying, all we did is let them know that the motion, we had sent them letters and had conversations with them that they had to hold on their phone because there was this preservation motion pending. Don't throw anything away. So then when the motion got denied, the Commonwealth just let them know, all right, the motion was denied.
yeah,
Um, and
yep,
then she she said that all issues explored. So he was saying that they like explored all issues and this is meaningless. The defense shouldn't be allowed to talk about it at all. And then the defense says, we don't believe what he just said was accurate, just like Bob said. And the judge said, let's wait and see. We're not going to sequester the district attorney, though, because she's basically saying, I don't really think I'm going to let you call him, or she would allow the sequestration, meaning he can't talk to anyone, he can't be in the courtroom. And then Yannetti, kind of spoke up again and he said, well, there is something I can't get from anywhere else that he injected himself into. And the judge knew right away because she chimed in as soon as he started to say that he injected himself into some aspect of this. She's like, do you want to play that on the video? Is that what you want to do? And he was asking like, well, no, I mean, that might be an option, but we might want to call him. There's a conflict. He let him know on the phone that Kevin Albert was on the force and the DA was involved and all that stuff about the kind of like investigation and the fact that the DA knew that Canton, who they were supposed to take off, was on and that this information was still being relayed back and forth and he did nothing about it. Um, and then she left it with, well, whether there's another witness who can cover this, you might be able to call the chief. And then they said, well, the prosecution says the chief might be too sick to testify. And she was like, wait, I've never heard about this before. But her end all be all word was, this is all a stretch. It's going to be an uphill battle for you right now. This offer of proof is not enough, and I'm not subjecting him to sequester.
yeah. Yeah, it was. That's what I'm saying. I mean, the things that I felt were the most germane, the most important to what the defense is trying to accomplish here, she either denied or she put a pretty heavy brick on it. And look, like it's not unusual for a judge to say, "Look, I'm not going to let you bring it up in opening. I need to see you prove it up a bit," which is fine. And that was another thing. That we don't know the answer to. Like in Illinois, we can reserve our opening until the beginning of our case in chief. I don't know if that's an option in Massachusetts. I mean, it's not common. I mean, we typically, because you can make the argument either way. Do you let the state get their opening out there and it goes unchecked for depending on the length of the state's case in chief, it could be weeks. And then you finally make your opening
And I was suggesting to Bob, I wonder with a ruling like this, where there's so much she's not allowing in the opening, if he could have said, well, what do you think about a bifurcated opening where you let me do my opening in the beginning and then you let me open on the stuff that you've decided I'm allowed to do when it's our case in chief, which would have been,
perfect world shit.
Interesting.
Yeah.
It looks like Jersey Jen has jumped out, but we appreciate her.
That was a long
It was a long time ago. So and Melanie Parker is right. So according at least what we have heard, we being the public, is that the feds did their own analysis, reconstruction, and that they're saying absolutely positively not a vehicle could not have done this. Now, is the video the judge was referring to that same video we watched? Because if it was, she was being snide and sarcastic when she said, do you want to play the video?
I don't know.
So
I'm not sure. I mean, there's a lot of videos. Like the thing that I didn't know what they were talking about was where they were having the early conversation regarding, how much of this one particular video Lally was talking about playing, because it was super lengthy, and that
Yeah,
was the whole
she's like, "I
conversation.
listened to it. I found it all relevant. Do you guys
Well,
just wanna play the whole thing? I just need to know, just for a timing thing, I need to know." It sounded like she was saying, "You should play the whole thing."
right, like, that's when she said, there was one time that we, watched a whole
Whole
movie during
movie.
a trial. I was like,
Oh.
"Oh." So, all right, I already threw everything up there, babe, while we were talking.
Oh, good, wonderful.
We're going 2:30. I streamed all day. I'm out of gas. We love you guys so much. If you're long timers, we love you for being here. If you're new and you dig the content, maybe throw us a subscribe. Make sure you like on the way
Or a
out.
like.
It
Yeah,
helps
just a
helps in
like will
the
do.
algorithm. We're new and growing, so every little bit helps. And if you really like us, maybe become a member. But make sure you at least like and subscribe, because that really helps us out. Thank you so much for being here. Thank you so much for everybody that was so generous. I gave you guys the love on the screen. You guys are amazing.
It looks like
Beyond.
we have like 1,000 people now and 200 likes. So
Is that where you got? I think you got to refresh. We got to have more than 200 likes. That would be insane. Like, and of course to our mods, we love you guys. We're sorry we kept you up late, kept you very busy today. I know with the streaming the Daybell trial, it's been a very long day for all of us. So, and Melanie, if you're gonna be doing that tomorrow, I'll be sure to check in. And I think that you and Allie should do a power woman lawyer live. I think that would kill. I think that that's something that the world needs. Two badass women attorneys, just two badass attorneys, period. Like, it doesn't even have to be women, but you guys are just both powerhouses. So I think that would be super cool live. So, all right. That's
cover
it.
the Supreme Court argument from the other day.
Yeah. I don't know if Melanie was in here when you were, when you went on your Idaho Supreme Court rage over the abortion issue up there, but I'm sure that you guys.
Well, it's really the refusal to give women actual emergency medical treatment if, because of a medical situation, they need a medical abortion, that they have to wait until they are on the brink of death, leave our hospital because our doctors can't help you until you're about to die.
Yeah, you're right. The concept that they don't think that the federal government should.
Whatever you're doing to your microphone is killing our ears. Whatever you're doing.
Oh,
there.
sorry. I was saying, but they don't feel like they should be able to tell, corporations such as hospitals what they have to do, but it's okay to, it's okay to control what women can do with their own bodies. Makes sense. Really makes sense. So, yeah, with that, we'll wrap it. Like I said, we love you guys. Thank you for hanging
Thanks,
for so long. And we'll see you on the other side. And remember, without you guys, I'm just an old man
talking about a shit ton of cases.
Talking about a shit ton of cases. We'll talk at y'all next time. See you later.
Bye.